All right, well, thank you very much, everyone, for attending. My name is Joe Bach. I'm the president of the Rutgers Federalist Society.
And I'm Tim Darwinian. Follow that, I am the secretary of the LGBTQ caucus of the law.
Well, today's debate is, does the Constitution guarantee a right to same-sex marriage? Our first guest from the Alliance Defense Fund is Mr. Jeffrey Ventrella. Now, Mr. Ventrella received a BME degree from the University of Newark in Colorado, where he specialized in trumpet. Mr. Ventrella then attended law school, receiving his Juris Doctorate from the University of California Hastings School of Law. Ventrella served the Alliance Defense Fund on its advisory cabinet, and he also serves as Senior Vice President of the Office of Strategic Training. Ventrella regularly lectures at churches and engages in debates on campuses and conferences throughout the United States. He has also lectured on 6 different conferences.
Our second speaker today is Mr. Ed Barocas. Ed is currently the legal director of the American Civil Liberties Union of New Jersey, and he has been since May of 2001. In his practice, he covers every corner of civil liberties, including free speech, religious freedom, equal protection, privacy, reproductive freedom, and the due process of law. Prior to working for the ACLU of New Jersey, Ed served as special counsel for the Special Hearings Unit of the Office of the Public Defender right here in Newark. In that role, he served and managed the unit's largest office, which covers more than 6 counties. Prior to serving as special counsel, Ed was an assistant deputy public advocate for the Division of Mental Health Advocacy in Wall, New Jersey. Ed attended Rutgers College in New Brunswick, received his Juris Doctorate from George Washington University School of Law. He's also taught a course here at the law school, presenting 4 areas of constitutional law in the context of Megan's Law. As a former intern of Ed, I cannot say how excited I am today that he'll be here speaking for us on this important civil rights issue.
Now, each participant will receive 20 minutes to speak. After that, each participant will have a 5-minute rebuttal. Then we will have a question and answer period moderated by Federal Society 1L Representative Michael McKenna. Thank you very much and enjoy this debate.
Thank you very much for inviting me. My thanks goes towards the Federalist Society, the most improved chapter, which happens to be Rutgers. And let me also say thank you so much for rescuing me from the 9th Circuit over a day. I am grateful for this opportunity to discuss this important, seems to be a consistent issue these days, about the Constitution and the notion of same-sex marriage. I come here with the full recognition that this topic basically violates all the taboos of polite public discourse. Because to talk about this particular question requires us to talk about a little bit about sex, a little bit about religion, and a little bit about politics. Of course, if you're put to sleep by that sort of thing, then it probably shouldn't be here. Also, this may be a bit presumptuous, but I want to talk about the winner of today's debate. The winner of today's debate is you, because you're here. My guess is that probably some of you are here because of free food, but perhaps you're also here because you have an interest in this issue, and you didn't come in here with an opinion in advance, closed-minded, not interested in exploring the different nuances of how this issue can be analyzed from a legal perspective. I'm assuming then that you came here trying to understand both sides of this issue. I want you to understand, too, that you're coming here to evaluate which side can be legally justified and which side can be philosophically justified. I'm going to be arguing, though it's not my burden to sustain it, I'm going to be arguing that the Constitution does not support, it does not require the recognition of same-sex marriage. So I'm not doing that because, I belong to the Flat Earth Society, or I think, SpongeBob is a threat to national security, or whatever controversy you want to put there. I firmly believe, and I think I can demonstrate, that I hold this position because same-sex marriage cannot be justified legally, nor can it be justified philosophically. Now, of course, my assertion doesn't make it so, and of course, Ed's assertion doesn't make it so. Rather, it's your job to evaluate which argument, which side coheres to rationality, is internally coherent, and corresponds to truth. because that's how debates are won, by arguments that deal with the truth, not by quarrels, not by emotional venting, not by bumper sticker jurisprudence, as if just saying things like civil rights or fairness or equity proves the case. No, we have to roll up the sleep of our mind and analyze this issue in this way. Or to put it in street language, good lawyers don't ignore precedent, they don't ignore history, that is to say providence, and they don't ignore the nature of the human person, which comes to bear on a particular issue. So let's be clear at the outset what this issue is about and what it's not about. Very important to understand it. This is not an issue about so-called sexual orientation. What I mean by that is simply this. That particular phraseology, sexual orientation, is a political phraseology. It is not a biological or medical or sociological phraseology. It is a political phraseology that was invented. Okay? Now, why do I say this issue is not about sexual orientation? It's very simple. Whether you look at the various constitutional amendments, 33 out of 33, or you look at the bureaucrat who hands out a marriage license, in no case do those pieces of positive law inquire about anyone's sexual orientation. The notion of sexual orientation is utterly immaterial to the notion of entering into a valid marriage. The second thing that's not relevant to this debate is, quote, marrying the person I want to love. Okay? Why? Well, why would we want the government, the state, to inquire as to the quantity of love and affection, let alone the quality of love and affection with respect to two spouses? It's not an issue here. That's a very strong emotional issue, but it's not a legal issue with respect to what's going on the marital horizon. I wouldn't want the government to say, oh no, we can't get married because we don't love this person enough. That's where we don't want to go. The third thing that's not an issue here is the notion of animus. Okay? Just because people disagree over an issue doesn't mean they're moral enemies and hate one another. So let's just put aside the things this is not about and focus on what it is about. What is this question about? This question is about the structure of a public institution. What does the state do with respect to that structure? The state has two functions with respect to marriage. First of all, the state recognizes marriage, and then secondly, it regulates within the confines of that recognition. Marriage is not a creature of the state. The United States Supreme Court held that clear back in 1877. What happens is the state recognizes and then regulates with respect to that. That's what's really at issue here. That's why the United States Supreme Court could say that marriage has a particular structure. Quote, the union for life of one man and one woman, which is the sure foundation of all that is stable and noble in our civilization. That's what the court understood when it was dealing with this very same question a number of years ago. The structure of marriage. Note, the structure has two components. A qualitative structure, it's male and female, and a quantitative structure, it's two. Now within that, the states regulate. People say, well, marriage has changed over the decades. Actually, that's a half-truth. What has changed over the decades is the regulation within marriage, not the structure of that marriage. Every time there's been an attempt to deal with the structure in a different way, the courts have rejected it, and that's been true in the religious notions of marriage as well as in the contractual views coming out of the Enlightenment, the sacramental view, the social state theory, the covenant. No matter what you do historically, that has been the case. Okay. Another thing by way of introduction is simply this. We're both arguing what the law ought to be. Notice then we're both making moral arguments. At some level, we're injecting morality into this debate. We shouldn't shy away from that. In fact, the Model Rules of Professional Responsibility, Rule 2.1, requires counselors to bring to bear a moral perspective on certain questions. So don't let anyone get sidetracked saying, oh, we're making moral arguments. Of course, that's the only kind of argument you can make when you're talking about what something ought to be or what it ought not to be. All right. Now, let's get to the legal issues of here. If we wanted to say the Constitution requires or guarantees same-sex marriage, we'd have to have a theory. We can't just have a slogan. So what are the theories that are out there? Well, many states have tried this. A lot of left-leaning states have tried it and have rejected it. Every federal court that's tried this has rejected it, save one in California, and that court did not cite the controlling precedent, which we'll find out when the thing goes to the surface and so on and so forth. But what are the potential justifications? One is either substantive due process / liberty interest. Another is privacy. And the third area would be like some type of equal protection kind of claim. Each of these are non-starters. They cannot be sustained on the analysis that we have today in our jurisprudence. Let's take the liberty interest one. A lot of people will talk about Lawrence versus Texas as being the foundation by which we deal with this kind of question. Liberty interest and so forth. Well, I think Lawrence was wrongly decided. I think poorly reasoned. But even if it were not, it still wouldn't justify same-sex marriage. It only dealt with private, consensual conduct that has been criminalized. It left aside the marriage question. But if we're going to analyze this from a due process or liberty interest standpoint, there are certain tests to apply, aren't there? What are the tests? Well, let's talk about two of them. One is this particular issue. You can only claim an asserted liberty interest if the claimed right is what? Objectively and deeply rooted in this nation's history and tradition. Same-sex marriage is simply not. It is a new thing. It is a novel thing. It is not there, so it does not pass that particular test. When you look at how the test has been applied over and over again, think of Glucksberg versus Washington, which dealt with the ultimate intimate private choice, which is what? Assisted suicide. The high court utterly rejected that because it would have had to overcome, it wasn't objectively and deeply rooted, it would have had to overcome this nation's history and tradition. The point there is that some conduct is deemed to be, legally speaking, so degrading to society that it doesn't matter if it's private and it doesn't matter if it's consensual. That will not carry the day on a liberty interest analysis. I would say this analysis applies even more with respect to something that is public, which is marriage. The second thing I think we need to understand from Lawrence versus Texas is simply this. They committed a method of jurisprudence that said, look, we're going to look out and see the experimental states and determine what's going on there and what is there a clear predominant trend. There, of course, between Bowers versus Hardin and Lawrence versus Texas, for the intervening 17 years, many states had decriminalized consensual sodomy as a result. And they said, aha, there's a clear predominant trend. Now, I think that's just very inappropriate for this proof. You don't put your finger in the wind if something becomes right, of course. But even if we were to apply that, Lawrence versus Texas, ask this question: what is the clear predominant trend among the states with respect to marriage? 33 out of 32 states, 100% batting areas, have modified their constitutions to reaffirm the definition of recognition of marriage as one man, one woman. So that's just not a non-starter. All right, but what about privacy? We tend to say, well, fundamental rights, privacy, Griswold, Be Ruby, all that sort of thing. Well, the trouble is that privacy says what? By intuition, you know this. Privacy says, stay out of my private life. What does marriage say? Marriage says, stay, come and regulate me. So on an intuitive basis, it doesn't work. By the way, marriage is a public institution. Now, privacy is certainly a component of the conjugal relationship of husband and wife. But just because there's a privacy component doesn't transmute it into something that should be guaranteed by the government. Many relationships have privacy. I have a private relationship with my aunt, conjugal, and the fact that it's private with some of my children and so on and so forth. So that isn't converted. Moreover, just because something is done in private doesn't require the government to affirm it. For example, dueling. Hey, what I do in the privacy of my home, no. The manufacture and distribution of child pornography, for example. We wouldn't say that, oh, but it's private, therefore it needs to be affirmed. So that's just simply a non-starter. It simply does not work with respect to that. All right, so we get to equal protection kinds of issues. Now, let's just make a couple of points here by way of preface. A lot of people will say it's equal protection and it's an analog to Loving versus Virginia, the decision that struck down the horrible anti-miscegenation laws. Okay? But that's just doesn't fit for a lot of reasons. First of all, here's what a gathering civil rights advocates said when this argument was first made in 2004. They said, we utterly reject the notion that same-sex marriage is a civil right. We will not tolerate the notion that marriage was the both created in the image of God and not be corrupted and undermined. To equate the lifestyle choice to racism means the work of the entire civil rights movement. So there's people on the civil rights movement that say, this analogy doesn't apply. Moreover, those who are scholarly in this whatever. I'm speaking of Paula Edelbrick, who's a law professor. She happens to be a lesbian by her own definition, says, to make an argument for equal protection, we would be required to claim that gay and lesbian relationships are the same as straight relationships. In other words, the argument is, if you understand working from legal jurisprudence, the two situations that are compared have to be similarly situated. Her argument is, no, we're not similarly situated, and I reject that. We're a distinct type of behavior and conduct, is her point. But not everyone's on the same page here. Having said that, let's go back to the standard equal protection analysis. What do you have to have? You have to have something that is so-called suspect class, right? Query. Is there truly a suspect class with respect to this? This has been tried over and over again, and not one federal court has tipped the fact that something called sexual orientation is a suspect class. Not one. Moreover, this very argument was tried right after Loving versus Virginia. It was tried, it was tested, and it was rejected by the United States Supreme Court on the merits, Baker versus Nelson. Still good law. So this argument, oh, this is just really easy. It's like interracial. No, it simply didn't work. What do we have in Loving versus Virginia? Mr. and Mrs. Loving were married. Okay. Loving versus Virginia did not deal with the structure of marriage. What it dealt with was an artificial, deplorable, discriminatory barrier to that pre-existing structure. It did not obliterate that particular structure. The racist laws of anti-miscegenation did not exist in common law. They did not exist in the New World. They were put in place thereafter to proscribe African Americans from entering into this particular institution of marriage. It was wrong when it was there. It was wrong when it was done. It was rightly struck down as being invidiously discriminatory. Okay, so it's very different apples and oranges with respect to that. Things were so bad, by the way, that we even had a Pocahontas exception to this horrible law. They said that the law didn't say that there couldn't be interracial marriage. Read the case. What the law said is that blacks can't marry whites. Clearly invidious discriminatory. Now, the Asians could marry non-Asians. The blacks could marry Asians. Indians could marry people. And Indians could marry whites because of Pocahontas. You see, this is just crazy stuff. It was rightly done. Very different here. What's the suspect class? And I don't say this in any way to step on anyone's toes, but I think that we're going to be analytic about this, which is what we're asking to do in terms of the Constitution. What's the suspect class? Is it someone with same-sex ideation? Who determines it, subjectively or objectively? Is it someone who engages in same-sex sexual behavior at some point in time, but no longer does so? Is it someone who engages that behavior for profit, the so-called gay for pay kind of situation that goes with? Is it someone who's on, the urban situation at the down low? How do we define this particular class? That's very important to do that. So I think we have to be very careful to say there's a class out there and so on and so forth. And by the way, is it an immutable class? Eric Holder recently said we're not going to defend the Defense of Marriage Act, and he cited a 1992 book called Sex and Religion, I think by Judge Close, saying, oh, it's really clear that this is an immutable characteristic. I happen to have a statement from the person who did the work on the gay gene. He says, his name's Simon LeVay. I did not prove that homosexuality is genetic or find a genetic cause for being gay. I did show that gay men are born that way. The most common mistake people make in interpreting my work. Nor did I locate a gay center in the brain. So this idea that something is immutable simply by genetics or nature is really problematic. And I think we have to take that into account if we're going to dump a legal doctrine and try to have it their way. Perhaps the Attorney General should read People Magazine. In People Magazine over the years, you see all these situations of people who change their so-called immutable sexual orientation, and age. To recycle, used to do with that virgin now to marry have children with a man. Sinead O'Connor said she was a lesbian on Saturday Night Live, and then now is married to a man. Elton John is married to a woman now with the UK civil party. Cheryl Swope, the WNBA poster child, had a great poster with her cheer husband when she was pregnant. Now she's decided her choice, not immutable. So the point is, there's these anecdotal things that say, look, this can't happen if it is truly immutable. So I'm saying it's very difficult to rest a legal doctrine on something that is so empirically falsifiable at that point. But let's assume that this thing is hardwired, okay? Now, please understand, this is a matter of logic. It's not a matter of, I'm using comparisons here, but not for purposes of substance, for purposes of logic. Just because something is natural doesn't mean it needs to be championed or preferred. There are a number of things, for example, genetic diseases, sickle cell anemia, cystic fibrosis, are natural. We don't say, yeah, that's a good thing. So logic doesn't flow. As a man, I sad to have to confess, sometimes I will lust after a woman who's not my wife. It's very natural. It's not good. So we can't rest a legal doctrine simply on something that's natural and say, well, there's the suspect flag. So where does that leave us? Where are the justifications? Well, I know, we'll go to sex discrimination, right? A lot of the great authors in this area will say, well, marriage law is discrimination of sex. The trouble with that is it doesn't follow equal protection jurisprudence very well. There's no subordinate status. There's no badge of inferiority based upon sex. Rather, instead, the marriage law applies equally to each sex. There's no problem with respect to that. And moreover, the United States Supreme Court has said where there is a basis for having sex-based discrimination, that can simply meet constitutional scrutiny to on Nugent case as well. Moreover, basing it on sex is really subject to a set of revisions. If, in fact, the issue is simply one of sex, well, then why can't two brothers get married? Where's the issue? If it's simply discriminatory based upon sex, or two sisters, or an aunt and a nephew, or an adopting father and a son, or a daughter, or both. You see, not that I'm saying these are equivalent, I'm saying logically, how do you administer that with respect to the law, other than being what? Arbitrary. And so the question comes down to, where's the analogy here? Well, the good news is, the analogy to same-sex marriage is not Loving versus Virginia. It's not sex-based discrimination. The analogy is the analogy to polygamy. Because in the polygamy cases, the court already addressed the issue of a challenge to the structure of marriage. And they rejected that, saying that's not what marriage is about. Now, the American Civil Liberties Union takes a different view. They believe that polygamy and polyamory and everything are constitutional. So that same-sex marriage, they're consistent. They understand that same-sex marriage is under-inclusive as a class. Okay, but then you have to then fight and say, well, then what does it include? Well, I've got the policy statement right here. So that's where really the analogy is. So again, where is the justification? Where is it on the doctrine about changing the very definition of marriage? It's simply not there as a legal matter. And these are tough questions, but I think they're clear questions. And I think, having said that, looking forward to your questions and the attorney's summary. Thank you.
So I'm so proud to be from right here, and I'm from the ACLU, so I have no problem talking about that. And I have to say that it was very interesting. It's the first time I ever heard the Anne-Heche defense brought up in this context. I'd like to thank the Federalist Society for having me here. And it's really an appropriate time to have this discussion, because we do have the property trials going on in California. And just 1 week ago, we did have Eric Holder and the Obama administration say they are no longer going to defend the main section of DOMA, that marriage must be between a man and a woman. There are two constitutional provisions. We talk about three. I kind of merge the idea of substantive due process and privacy, and then equal protection with the other. But before going into those, I want to take a step back, because a lot of the discussion has to be about, well, you'll have strict instructional judges on one side, or activist judges on the other to meet with the terms of the right thing to do it. But what I would say is instead of strict instructional judges, narrow instruction, in that they narrowly use all the terms of the Constitution. That when you have a grant of power to Congress, for example, they view that as very limited. When you have restrictions on what Congress can do, They also do that as a limited restriction on what Congress can do, and oftentimes you need Bill of Rights that are in very limited way. And instead of activist judge, I would say pragmatic judge. I think the Constitution would be extremely feeble if it was only able to address the questions of the day of the 17th century. Instead, what it does is it sets forth principles to address future questions that the country will face. And it's written in such a way so that it can take into account new issues, new information, and an evolution of thought. I think if you are to read one page as Lawson, hundreds and thousands, will be Homestead versus the United States in 1920. Not surprisingly, in my view, what's really interesting there is, not surprisingly, it was a dissent at the time. Since then, the courts have come around to that view. It was a wiretap, newfangled thing, wiretap, okay. And the majority said no such thing as wiretapping under unreasonable circumstances. It's not a document. We don't even know what wiretapping is back then. So you can't be protected from the government from wiretapping. But what Justice Brandeis said, and this decision is chock over good, for this purpose, he wrote, the court has repeatedly sustained the exercise of power by Congress under various clauses over objects to which our founding fathers could never have dreamed. We likewise felt that general limitations on the power of the government forbid the United States or states from meeting, that do not forbid the United States from meeting modern conditions by regulations which a century ago, or even a half century ago, probably would have been rejected as arbitrary or offensive. Laws is guaranteeing to the individual protection against the society, but that a similar capacity to adaptation to a changing world. Time and work change, brings into existence new conditions and purposes. Therefore, the principles of society must be capable of wider application than the mischief which gave it birth. What we have in this situation is an evolution. Okay? And it's not just an evolution of same-sex marriage, regarding that. Marriage has evolved in the last 50 years. You know, the idea of the structure of marriage versus the barriers to marriage versus the regulations of marriage. Marriage has changed. 50 years ago, the role of women in marriage was different than it is today. The court, however, recognized things have changed. Gender norms have changed. Women are not the secondary subject anymore. Okay? So this brings us, just as an introduction, to the two main provisions, constitutional provisions that I'm going to talk about. One is the substantive due process privacy rights, whether early substantive due process or the 14th Amendment, or Griswold v. Connecticut, which basically took another thing that Brandeis said, the right to privacy imposed at the government, the right to use alone, and really gave it teeth in Britain. And there was a recognition, whether it's under the 14th Amendment, the 9th, the 9th, or the penumbra, that there are certain areas in which the government does not have the right to tell us how we are to make our choices. Okay, the right to privacy actually is two problems. One problem is informational privacy, that we don't have to give over certain information to the government unless the government can show no overriding interest. And the other is that there is a zone of privacy in the most fundamental decision-making areas of our lives. Marriage, procreation, sex, childbearing, things of that nature. And that's what Griswold said. I like to think it comes, at least in part, from the 9th. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others maintained by the Constitution. If there's no doubt that the right to marry is a fundamental right in the Constitution, it is part of that zone of privacy. Sex, marriage, procreation, child rearing, all part of that decision-making area over which we, not the government, get to decide our choices within that zone. If something falls within that zone, we get to make the choices. The government can only come in and place a limit if there's a compelling need to do so. So, in a way, that's the whole ballgame for those who oppose same-sex marriage. They can't deny that what we're talking about here is the right to marry for the children. It's within that zone. And let me make very clear, New Jersey and New York, we are, in fact, talking about zones of privacy. You don't look to the individual who's making the claim. You don't look to the particular limitation on the claim in deciding whether something is covered in the claim. You look to, does this involve that bigger general zone? In fact, that is partly what Lewis, what Lawrence said was wrong with Bowers, the Harvard case, Bowers case of the conventional spousal of Harvard case. Because in Bowers it said, is there a fundamental right to consensual sodomy? Yes. Lawrence said, that's wrong. Something is wrong. If you have the right to the area of sex to make your decision. What happens next is, then you look to the limitations and say, does the government have compelling interest? So for the right to marry, not absolute. You can't marry a virgin. I declare to compelling interest, but there's no consent. So what do the opponents of same-sex is try to parse the right. You say, no, we're not talking about a right to marry. We're talking about the right to same-sex. Again, exactly what Lawrence in Texas said, exactly what the New Jersey Supreme Court said, which is we look to the right of the. In fact, it makes no sense to look to the particular question that we're raising. Because whenever you're raising a question saying, we've been denied this right, but we think that we have it in the Constitution, that is right. If you don't look at that, well, if you just define it by the case you're running, you're always going. Women will always be victims. Including one that Justice Ginsburg argued on which is the Brazilian, about role of women as president or not, none of that's correct. They got this husband. So the question then becomes, is what is the limitation? And is there a compelling interest? Now, I'm going to get into the interest, but I think it's clear about some later in talking about the protection, that there really is no interest. Other than, I won't say the term animal. I understand how it's expensive, but I'll say that there's no interest in exclusion other than exclusion, or other than moral exclusion. But before going into the interest, let's look to people protection. And this is what I was told in the administration. I've said same-sex marriage is a right under the Constitution for protection. When you're looking at, let me just go back to one thing I want to say. You mentioned loving. And it is interesting. You don't raise the idea, you don't focus on the question, is there a fundamental right to interracial? You don't think that there are fundamental rights when you're analyzing the court to interreligion. You say, is there a right to marry? Then, how is the government going? Okay? And is that the implication? So, equal protection. If there are things that are not fundamental in the world, if there's no subject to that, then it's subject to the old rational. If there is something such as women, for example, subject to misgender, subject to kindness. then there's that heightened level of scrutiny in terms of that 30 or 80. You can't have an interest there, even under the rational, that is merely for you. Now, during the Prop 8 trial, the defendants had the ability to provide a whole load of reasons why they need to exclude. Now, one is, of course, merely the licensing traditional Russian marriage. Well, that's the case. Marriage will be changed in some ways. Women will be constructed role. Effectively, we have that protection. So, right to that condition. And why do we do that? Because the history of discrimination is not a valid justification to support future discrimination, for future exclusion. The idea that there were better men or women based on number one, that isn't true. Evidence that was presented in the property trial. But also, that's not really important. Really important. Say, okay, let's treat people by the class that we're in. Let that alone. Let's separate people by class. Let's separate them by hourly wage, separate them by ethnicity, let's separate them by race, let's separate them by what state they're in. And we found out that people from West Virginia make the worst kind of people. So we say, people born in West Virginia. Why? We have a compelling interest in protecting our children. We don't treat people as class. We don't say, oh, the Irish, they make horrible parents. Look, we have 2 kids. Or whatever, into ethnicity. And so, we don't do that anymore. We don't treat people like class. We treat people as individuals. This is individuals' right to marry the person that they choose. Frankly, it's not about love. And it's not about, it is just about being unemployment. I'm not sure what marriage is. It's not about that. Of course it's about that. Of course it's about the transition of position. I can't see it. So it's hard to say that. The leader is supposed to have that. But it is about the idea that you find the sentence. I think for but, and they actually said before, hopefully not that it's going to do that. But the idea is, we're talking about things individuals. In America, we don't treat people as the idea that children will have a hello life. We live with that. The idea that if people will make life harder last year, then you shouldn't have a life. I represent these kids in South Jersey that wore T-shirts that said, "We used to be friends with me if I was black, Jewish," and the principal actually banned the end-to-end T-shirts. He was worried that the skinhead students would get upset and make trouble. What the heck is this? Simply because the skinhead students is not a reason to deny the right to just those who right to stop after the community. As Eric Holder tells us, moral differences are considered that's all that we were left was moral differences and stereotypes. I think stereotypes, to put it in context, the idea that tradition, let's just have tradition, moral tradition, and we don't do that, not if it's differentiated in this way. So it doesn't even rationally. It doesn't mean heightened. And it clearly doesn't the component. If you just turn to something, perhaps in this discussion, the question is the subject to the idea of having scrutiny and how it is. But, just the saying is Liberty protects the person from unwanted government intrusion into money or other private benefits. In our tradition, the state is not in the home. And there are other theories of our lives and liberties outside the home, where the state should not be a dominant presence. Freedom extends beyond spatial life. Liberty presumes autonomy of thought that includes freedom of thought, belief, expression, and certain infinite conduct. They also include infinite choices, values, and desires. If we are to truly enjoy freedom, the idea that this is within the God, our fundamental content, not in itself, but in choices, will and will. We have to recognize that this is a fundamental. I would just like to point to Pierce v. Society of Cities, which was about the right to bring up a child in the education of the choice. Another one, just like marriage, just like procreation and raising of a child. But all that same type of dominant type. So in Oregon, that said you have to, as a child, go to public school or certain schools like in a Roman Catholic school said, wait a minute, sorry, not the school, parents said, I want to bring my child to a Roman Catholic school. I should have the right, within that zone of privacy. The court didn't say the question was, do you have the right to educate your child in a Roman Catholic school? Or bringing it to more modern. The court didn't say the parents were similar chapters now or similar as well. The court wouldn't say, do you have the right to educate your child in a Montessori school, or in a cosmetology, or in an ethical culture society? And the court didn't say, wait a minute, that never existed as a traditional notion. Scientology is something new. Montessori has been in the last 30 years. You know, ethical culture society, they just became what they are. You know, it's not defined by do you have a right to bring your child to a Montessori school, but do you have the right to raise your child in the God. You don't focus on accepting that right to force decide that it's something you look for. And that's what we have. This is within the right family, this is the right to choose, well, you know what, I'll get to the question of civil unions, this is our questions on that, and why that doesn't satisfy. Thank you very much. Now, Mr. Ventrella will have 5 minutes for a rebuttal.
Thank you very much. Good to see the ACLU on the record promoting alternative schooling for parents and vouchers and all those things. I'm glad to hear that.
I didn't think vouchers.
Of course not. Of course not. Illusionary. No reason for that. Let's talk about tradition for a minute. Look, marriage between one man and one woman is not right because it's traditional, and nor does I make that argument. It's not right because it's traditional. It's traditional because it's right. That's what the courts have found, and you can understand this context. The notion that there's been this, exclusionary policy is just a lot of rhetoric. Let's give you an example. Civil unions. 40% of those who entered into Vermont civil unions were previously heterosexually married. No one was denied the right to be together. They just had a different choice. They flip-flopped, or whatever you want to say. And so to say that legally we're going to predicate a doctrine on my simple subjective choice, first of all, with respect to marriage, is under-inclusive. Under-inclusive because, let me put it rhetorically, bisexuals are people too, right? So why can't I be married to 2 other people? Who are you to judge? I mean, I want to be with the person I love. All these subjectively based arguments create chaos. And you can say, oh, well, this is compelling interest. That's just a traditional rejection. That's all that. That's just tradition. You're not open to what you see. So the argument really doesn't carry weight. It doesn't really have traction with respect to that. Why does the state in the marriage business? Why doesn't the state regulate friendships, for example? Which is productive, there's relationship, there's dependability, there's mutual support, there's affection, there's love. Why is it? Why do we have this thing called the recognition of marriage? The answer is very simple from a legal perspective. It's to channel responsible procreative activity. Now, I'm not saying marriage license is license procreate. It's quoted from the standard. What happens is the state recognizes that men and women get together, whether by design or by whoops, children occur. The very future of what's going on. Same-sex relationships, in the nature of the case, are infertile. Bill Eskridge, a colleague of mine who teaches at Yale on the other side of the district, brilliant man, will admit that. He admits it in his book, The Case for Same-Sex Marriage. He says, look, in terms of the future of society, a same-sex couple requires an intervention of a third party in order to have that particular next generation. The state recognizes when the original law against deadbeat dads is marriage. You see, when you don't have this channeling of responsible procreative activity, you have abused women, neglected children, and irresponsible men. And so the state has an interest in channeling what is inevitable when men and women get together. Now, one of the disasters in this area was not caused by those who engage in same-sex behavior and so forth. The big disaster in American culture was this, what I would call the elevation of choice to being deified in the form, in the law of no-fault divorce or any divorce. Any reason divorce created this climate of, hey, I want to interview the person I love. My guess is in the classroom of this demographic, the first time you heard that argument, I just want to be happy. I want to be with the person I love. When dad walked out with your family. Because that's typically what happened. That's the rationale for destroying relationships in the fabric of society. And so this idea, be very careful of having it smuggled in highfalutin rhetoric, and I just want to have my own choice for Capricorn and Chip. It's destructive, and we can demonstrate that demonstrably all across where it's been rampant. So that simply doesn't hold legal water. I'm actually surprised that the argument's being made on privacy kinds of notions. Again, this is not the case, and the courts have made it clear that's not the case. It's been rejected with respect to that particular issue. The final analysis, so you have to come to ask this question. Is, in fact, same-sex marriage anything other than ideation, or is it an inferior similitude? For example, we can talk about the notion of square circle. We can be enthusiastic about square circles. We can create justifications for why we have to have square circles and not exclude them from our geometry textbook and curriculum. But the fact of the matter is, you're never in your life able to draw an actual square circle. And I think the same thing is true here. There's really, in the bottom line, no justification under the Constitution for something called same-sex marriage. And even if there were, it would be mightily under-inclusive. Then what you basically have is chaos in society. In respect to that, that's simply going to be the consequences. We can talk about the sociological stuff if you like, although WebSocket is the sociological policy theory that I'm glad to talk about and take your questions. This is your Thank you.
I'm not sure how to respond to this is the way it is because that kind of thing is about the when you understand what it is not really clear. The idea that marriage is procreated, it's setting up our relationship, either procreation or stable relationship. The idea that just procreated and you have to do that. The idea of stable relationship underway, because there are thousands, tens of thousands, people even just who are in that relationship. That, as you say, marriage makes things more stable. It makes things more stable for each other. So the idea that we're not getting that stability, undermines that stability, not a thing to same-sex marriage. There was the issue of love and lifestyle. I think but you know, I don't. It does matter. It does matter. But I don't even have to rely on it. I think that what this is really telling you is that, and you're right, you have to take this position to continue to think about constitution, stable relationship with a man under the constitution. You have to take it to that. It's not about choosing to do that. And you kind of mock constitution doesn't, you know, make right to the captain of an iron ship. That's exactly what it does. That's exactly what the Constitution says. There are certain areas, just those areas, not everything. None of the constitutional rights have nothing to talk about. You know, there are certain areas that you are the captain. Those are reproduction, those are birth control, right to abortion, right to marriage, right to children, and right to certain amount of things. They can only, you are the captain, and they can only be overridden by the Constitution. So it's a fundamental misstatement of the law to kind of mock the idea that you are your captain. And if you want to marry just for procreation, saying I'm going to look for the person with the best genes for procreation, or we're not going to choose me, we're going to choose someone else. Okay. That's fine. That's your choice. If you want to marry for love, that's your choice. If you want to marry to please your parents, that's your choice. It's your choice. That's the point. And that's the constitutional point. That was in the right to privacy started in 1948 and clarified by the U.S. Supreme Court in Rutgers Federalist the idea that this is not about sexual orientation is the same. Because we're not saying you can't have sexual orientation. We're just saying you can't marry. There's a great line, I think it was by Ken, that said, a tax on Yama is a tax on Jesus. Okay, in other words, let's get real. When you say you can't marry a person of right sex, you're denying a right to people who choose someone of the same sex to marry. So it's really improperly listed to go. And then again, I'll wait on your talking about it.
Thank you very much. We will now go to our question and answer period. Micah Piquet will moderate. In your questions, please be brief, courteous, and announce your name and class you. Thank you.
My name is Mr. Ventrella. I had a question just basically about your bio-related opinion, because I'm trying to understand if there are federalist opinions or I understand from your bio that there's sort of secrets of the federalist society. But then again, I looked at, thinking a little bit, and I see what you do at the ADF is training lawyers, Christian principles, micro to human rights, pretty much a little bit of a Jewish outlook, all the things you can get. We go on to define that people are seeking to embrace the right thing, at the right time, with the right action. So I guess my question is, are you a federalist? That seems like you're working to create activist centers and other individuals in society, but just activist for your game.
So when did I stop being a lot? First question is that I'll check for you. Where do my opinions come from? I did a constitutional analysis, certainly within the umbrella of Federalist society. Most people who claim to be Federalists are not Federalists. They are anti-Federalists. Federalists understand the need for a uniformity when it comes to the issue of marriage. For example, in the United States, as the Western States refers, the federal government, Congress, required the sustenance of the structure, I told you, one man, one woman, with respect to marriage, as a condition preceding for coming into the union. That was for 5 different states, because a number of states had attacked the structure of marriage and polygamy and other kinds of relationships. So So the argument I'm making is exactly that same argument, that in fact the structure of this is denying the federal considerations of handling that particular situation. Now, if you're saying that motivation or opinions that have a religious component don't represent true knowledge, then I think we need to revisit the understanding of Christology. You can't rule out any extent the notion that religious knowledge is somehow not as persuasive or not as cogent or not something else. I didn't make a religious argument. So now you're arguing we have homonyms, at least perceived to be in the background, which is fine, but that's not really what we're talking about here. So you have to jump over a number of hurdles to get to the point where you can be question about this sort of thing.
You wouldn't have to take a set of boards and understand it with each lawyers who are one advice to them that we can act.
Such as?
Well, believe that homosexuality is not sexually somebody born. I mean, I would find that immoral.
Yeah, I'm not sure if that's been debate. I mean, I certainly have personal convictions.
Well, I'm not sure if you're a Federalist today, okay. Sure. I heard your argument. It just seems like when you go home, you're not like, you're trying to make answers. I'm not sure about that.
What did John Adams and George Washington think about things that day? As well as James Madison. Have you read the materials? What do you think about it? They were opposed to it. Correct.
We're not with that. And look,
So I'm not really to move on.
yeah, I'm going to move on, but I do want to say something you're not related to, particularly something but otherwise related. That the kind of thing, yeah, don't get this. Yeah. The other thing is, as far as I'm not as far as the role of religion in this debate, the only thing is that, as some of you in the public have, the government does not, cannot choose one religious view over another and say, this way. You can't say, this is the Catholic view of religion, of marriage, and things in the one time. So we didn't do that. There are numerous religions that I belong to, the one that my married lesbian colleague belongs to, and she was married under God. Because in her faith, she was very bad. She was allowed to marry under God another woman, or a man, another man. So the idea that any religion is whole well, take a picture and who knows? How you make them up? As far as what are state for the government, they can't do that. Again, that's true. But if you're talking about it in a religious sense, there is not one state. There are numerous religions that say, yes, marry under God.
Yeah, I actually have a lecture that lasts like 45 minutes in this question of harm. Let me give you the highlights. First of all, we need to understand that how do we define harm? Okay? Harm to whom? For example, if you're just talking about the participants in same-sex behavior, the statistics and the studies are very clear in this regard. For example, take one aspect, intimate partner abuse, okay? Which is horrible and I've seen victims on both sides. But intimate partner abuse with respect to two women living together is 18% higher than when many women live together. 18% higher. With respect to two men living together, it's 3 times the rate of a male and female cohabiting. So those people are harmed. I don't want to get into the physiology of certain private behavior, but those statistics are there too.
As far as that's
Right.
concerned, I don't know.
Right. I've written a number of law reviews on this. I cited this right.
Okay, I'm
So-
conceding, but I'm saying that the difference there is you're not making people live in the way. I'm asking what is the harm in being there?
Right. And I'd be glad to see it. First of all, we need to understand what the definition of harm. In the law, harm, a lot of people when they ask that question want to deal with this. Hey, the sky's falling, the earth opened up, fire and brimstone came down. That's the kind of harm you expect, otherwise I'm not going to pursue it, right? That's kind of, but that's not what the law recognizes. That's not what the law recognizes. That's multiple times. The law recognizes that harm can be what? Delayed. That's why we have tolling provisions. For example, when a minor has some type of tort injury, particularly in areas of sexual molestation or abuse, we have a tolling provision, right? Because that harm may not manifest itself. When you have ionization, radiation injury, there's a tolling provision. Medical malpractice has what? Discovery statutes. So the law recognizes that harm to be valid need not be immediate and catastrophic. It can be dormant for a number of ways and raise it up. Well, if you look at that, then you have to look at the issues of, for example, Carl Zimmerman in his 1947 treatise, Family and Civilization, or perhaps before that, the Cambridge anthropologist, Joseph Unwin. Joseph Unwin set out to show that the behavior, the sexual behavior, including marriage, is irrelevant to society. Different strokes for different folks. He didn't have to show. What Unwin found, however, was exactly the opposite. What he found is when a culture or a society abandons what he termed absolute monogamy, i.e., marriage between one commitment between one man and one woman, okay, that produces what he calls the optimum societal energy in culture. When there was deviations from that through fornication, through adultery, through commission of divorce, so on and so forth, through cohabitation, homosexual behavior, and so forth, there's a dissipation in terms of overall societal, what we call energy and so forth, productivity and so on. I'm summarizing it here. But what he found was that it took 40 to 45 years or so for that harm to manifest itself. And so it takes time. The fuse is lit, but it's long. Another thing I would say about the harm question goes to the issue of the pedagogic function of law. Law, in fact, is pedagogical. What we say, this is the law, teaches those around us. Part of the spur effect that affects some people. When we establish the matter of public policy of same-sex marriage, what it communicates is that it's okay to have fatherless and motherless environments, that it doesn't matter that there's an input, that there's an absolute no distinction in terms of rearing the next generation between male input and female input and so forth. So those are pedagogic issues that are being studied. Now, in terms of what the impact is, sociology will give a snapshot, not absolutely. But I'm aware of this book by a couple of PhDs in the Chicago site. It's called No Basis. What the studies don't tell us about same-sex marriage. There's a lot of falderall that says, well, these kinds of things doesn't really matter, these are just the same. It's actually not true. There's all kinds of problems with sociology, stuff that's been ponied up there. So I've just given you a nutshell. I don't want to be self-familiar. Reading my law review articles is fine. Follow the footnotes, and you'll see the harm question all over the place. Now, if in fact we just hope to Bill and Ted marry their next door, does that harm my marriage? Well, if you're saying it's immediately or so forth catastrophic, of course it does. We're not talking about that. We're not talking about individualistic. The law says, there's a great Seventh Circuit case on the Holmes Smith side of the precedent, that you can't evaluate a particular case and instance when you're looking at consequential issues. You have to look at the entire potential impact. The same is true with respect to talking about a policy. So in that sense, that just gives a good guide for anyone who's not allowed to visit a licensure. I'd rather talk to you elsewhere or confer or email about on a question. But it's a very interesting question, and if you get a mind around the notions of harm. Plus, there's also this notion of moral harm, which has been falling out since we suggested natural law theory which is full and so forth, the notion that some things are wrong per se. And we leapfrog over that. There's some things that are wrong per se. And we talk in the field, we can say all kinds of things, but we just kind of leapfrog over that. Someone needs to ask that question. Someone needs to answer that question in a coach pulls off the way. Wait a minute. Is this notion of same-sex behavior in this way wrong per se? Okay? So that's just in a nutshell. To go on.
Just quickly, yes, sexual activity outside of marriage, but the idea that, it's not as if same-sex couples are right, you can't get married, people think it's wrong. All right, we're going to change it. I'm a guy, I'm married to a woman. And so, frankly, I hate who in that get through the child at that age. What those studies? It should be 45 years to that. What do you look at it? I think we had it in New Jersey. The idea of adoption by same-sex couples. And in New like 80% of things in states, Louisiana, who adopted a child. What's the state with the lowest divorce rate? That's true. I don't really know what I can say for others. No, well, no, I don't think that's necessarily so common. People go into marriage when they choose to go into marriage. And I think that says something about the world. And I think that the only people who are hurting are not allowing marriage. This happens. What's the harm that comes to the child? You're not going to stop same-sex couples from getting together. You're not going to stop them from having a child if they want to. All you're stopping them from is having a family and a wife that will protect them from a child.
Something to follow up on that, if I may, I think is important. Notice that the assumption here is that marriage is one viable option among many. I reject that. I think, particularly with respect to parenting and rearing children, marriage is the optimal environment for rearing children. That is the optimal perspective, one man and one woman in marriage. And so this notion of a smorgasbord of sexual behavior and each is valid and each is equal, I think is mistaken. I think that if that weren't the case, then what happened is those who are clamoring for same-sex marriage say, look, we can marry now, and so let's not go, do these things and those things and those things. Let's just all get married. You don't see that. There's a reason for it. Then other nature of harm that needs to be said. I don't want to bring this up, but since you mentioned the question, the notion of religious liberty. You make the famous statement now by Commissioner Counsel, who said very clearly, where religious liberty and sexual liberty clash, I can't think of a case where religious liberty wins. That clearly affects and harms culture with respect to religious exercise. And so that form of harm is there. She's now a commissioner on the EEOC, and she's saying, no, anytime there's a conflict, religious liberty will suffer. That clearly produces constitutional harm. And by the way, First Amendment protects religious liberty specifically.
Anytime religious liberty is, or anyone that you go, religious liberty is harmed because they're being forced to have a marriage, or forced to perform the marriage on someone else. Give me a call, or attention.
All right, what about this situation? What if two people are married in Massachusetts and then want to go to a church that has a married couple retreating with the married couples of the same sex? Can the church refuse them as a public accommodation? Absolutely. That's not the example of the
That is the example.
contact rate.
You have a church, under the law against discrimination, churches are exempt from the New Jersey law against discrimination. So if they want to choose people coming up their faith,
Okay, what about Ocean Grove?
Ocean Grove. That's the question of a pavilion down the shore. Church-owned pavilion down the shore that owned by the Methodists of Ocean Grove Methodist. And they own a large portion of the town. They have marriages on their pavilion, which is and a lesbian couple choose So we use it. And they said, no, wait for the United States. Period. This was not being known as church type practice. This was known as a business. But even more important, the Ocean Road Methodist Society told the state of New Jersey, we want to get the special green acres tax. We agree that under this tax grant system, we have to open up our facility to all comers. We cannot get this. In order to get this special tax system, they should synthesize it for that. There's, no one is saying that we're a church. It's a civilian that was run, everyone is business. In other words, it was open to all. It was open to pay us money, whoever wants to come here and do it. But that being the capitalism is shit. That's a different question. That's an individual right for us. But the biggest thing is, so you think it's okay to tell, make contracts with the state to say, we will get special dispensation, special funding, green-acre funding, environmental funding, by agreeing to make everything open. And then take those funds and say, oh, wait a minute, we're a religious group. So that contract that was signed, that one clause doesn't apply to us.
You can't make a clause that's unconstitutional.
Well, they don't sign it.
Well, that's true. They can't find them under unconstitutional clauses. What you're saying is there has to be a religious exclusion that only the religious brings to impact on conviction. To do that, you can discriminate against religion. We can go on and take it later, but let's move to the next question.
I had a question about the qualitative pressure of marriage to be one man, one woman, and also depending upon the distinction between identifying sexual orientation and sex. And there's no society having a transgender, transsexual, and more recently, even more complicated question in the case of South African printer and before her Olympic medalist swing, where the scientists that actually evaluated the question basically determined that we don't know. We don't know because there's a question of testosterone and all these different things. So where do they fit into the qualitative structure? And would it be possible to take deny them the right to any sort of marriage simply because they cannot prove they're either man or woman?
Yeah, the question there deals with the whole genetic issue in the world is simply imperfect. I would, rather than go on and on and on, I would go and search on the web for an article called Sexual Surgery by Dr. Paul McHugh, who headed up the head of psychiatry at Johns Hopkins, who addressed that very issue. It was probably in 2004, 2005, and I'm guessing November, but my memory could be dim on that. But he addresses that and talks about, interestingly, there's embryogenesis, who can actually tell the sex of the child distinctively, genetically, at a certain point during the developmental time. The fact that there is malformed genitalia and those sorts of things, what happens is he concludes by saying, we took the wrong approach in psychiatry. Okay? We said, let's just try to shove someone into this thing, irrespective of blood chemistry and so forth, and the hormones, and try to make this happen. Because we have collaborated with anatomists. These things simply do not work. There's mental illness and so on and so forth. So it's a very interesting. He goes through and talks about his colleagues have done very longitudinal studies on this kind of question. Excellent question. It's clearly an exception and a very minuscule issue. It's very different from the question of well, I just don't like the choices I get to make in terms of marriage.
It's fun to note that the things that you would be very surprised allow same-sex marriage. Second, the Texas has come full circle, at least for this group of people, and that is that people are, in Texas, you are what you were born. You are what you were born. If you were a male, it doesn't matter. Not only do you take hormones in life, but you have become transgender, have the surgery and everything else. You become a woman. You may be a woman, sight, sound, thought, emotion, but under Texas law, you are male. And you are actually only, therefore, allowed to marry another woman.
Which is the Q's article makes the point that's exactly the correct thing. And from a medical perspective, a psychiatric perspective. Let's get with that.
First here, you mentioned earlier that religious liberty is over sexual. What if I
No, I didn't say that.
No, the first.
I was,
Sorry?
I'm sorry, you're talking to
Yes.
what I was quoting was Kai Feldman, who said that sexual liberty will win over religious liberty in her mind in every case.
Right, you agree with me.
Correct.
Right. So what if I start a religion where part of my religion is that gay people can get married, and the government denies my and my people the right to marry?
I missed the premise. I've got plugged ears. But
I'm sorry.
you started a religion.
What?
You started a religion that said what?
Under my religion, gay people can get married. There's also a non-consequential fact that gay people exist. But then the government denies me and the people of my religion to marry.
That gets back again to the polygamy case, where you're dealing with the structure of marriage. I think that as the basic societal building block, the government can say that we recognize marriage. We can't create marriage. Marriage is recognized. It pre-exists. Transcended truism. Consequently, it has the structure that's quantitative and qualitative. Okay, quantitative and qualitative. So I think the government may well be able to say, well, you can perform a ceremony, you can express that as part of your dogma, but we are not bound to do that because, again, religious exercise is not an absolute issue either. E. Smith.
The fact that religious liberty is not, that we're sort of Christian, not other.
Well, that was certainly, I mean, I don't, that's an insult. I mean, that's just a story stuff, right? I mean, that's just his understanding of the First Amendment. He was not a Christian. He understood that when the founders, look, as a textualist, as a federalist, as a originalist, right, they didn't say religious liberty. We use that as a shorthand in the 21st century, right? But what the text says is religion, a nominative thing, and it didn't include all forms of convict and heretic. Now, we can debate whether that's true or not. We can debate whether we should evolve on that. But from a textual standpoint, there were certain things that were not considered worthy of religious liberty. Now, we can debate that, and I would like to debate that, but I'm just saying from a textualist, federalist standpoint, there were some that would say, no, we're not going to do that. In other words, you can't have subversive stuff that undermines your thing. For example, I'm Italian, I'm from Italian. The Cosa Nostra is a very religious organization. They have sacraments, they have all these kinds of things, and that, the other thing. And we can't say, no, you can't, deal with our, you can't arrest us, but we're dealing with our religious liberty. We're exercising our freedom of religion. Well, no, you're being subversive and it's criminal conduct. So for the common good, obviously you can't just take one thing like privacy or religious liberty and make it drive the entire bus.
I think the people in this room are going to reject me out.
as the Supreme Court did, and I ask you, are you saying then that his religion is subversive because he believes that the connection to God that a man and a woman share can also be shared by a man and a man, and therefore his religion is subversive religion?
My reference to Justice Story is when he dealt with what he called the muscle man. That was his illustration. I think it's easy to think of it hypothetically that some religious tenets would be subversive, and I think we have to understand that.
And if they're actually subversive and criminal, then they're becoming interest to not a criminal act for harm another. But one person's belief, in fact not one person, one clergyman United Church Party allows same-sex couples to marry. He believes that that's happening between a man and God, and a woman and God. He should be exactly as part of the religion. What you're saying is because some form of man and woman is just right, why? And so that they lose their religious liberty to have civil rights attendance to that government.
Well, no, that's not true. That is not true. I mean, Hawaii brought this years ago, when it had in their constitution something called beneficiary provision, which said, look, we're not going to recognize same-sex marriage, but if in fact there's an economic dependency and so forth, let's not be under-inclusive here, and let's allow those to occur. You still have the religious service still be recognized as a factor in that particular following. So you still have all the contractual and beneficial rights that you expect of them. So that's what's really a straw.
Okay, so what you're saying then is you can have religious marriage between a man and a man.
No, I disagree with that definition.
Well, then you're saying that you believe that your religion can get out. Well, if you're saying you're talking all about religious freedom, you're talking all about religious freedom, but yet there are religions that disagree with you.
Right.
Religions that say a man and a man can be sacramental. And we want that.
The answer goes from what I told you at the outset. I've a good lawyer going to precedent, which I covered, going to work history, which I also covered, but I didn't get to the point of the nature of the human person. You have to understand that humans are not like Mr. Potato Heads, where you can just make up stuff as to what humans are or are not. Rather, there are humankind is the design is mutually respectful dignity consisting of maleness and femaleness. And when that coming together occurs, it is complementary. It's not simply companionship. And therefore, there's a key issue here of biology that has to be taken into account. And so when we look at the nature of the human person, I think we're able to draw distinctions and say, wait a minute, there may be behavior there, but we're not going to call that particular behavior marriage, appropriate species, or whatever angle you want to take. So, I mean, I reject the notion of saying we're being arbitrary. I'm not being arbitrary at all. I'm actually taking into account the fact of that mankind is wonderfully and creatively communicated and so forth.
Well, my question is then, does the fact that certain religious sects, maybe that's marriage, and that stuff, in other words, you're saying the religious customs are irrelevant.
Yeah, yes, Kai Feldman, which is supposed to reject
Well, I'm
it all.
Just one quick response to that, and then we'll move on to the next question.
Yeah, I mean, I think I've answered the question.
So, two things. One, I hope when the federal government has a law that they can't have property next year and my right to
I know, although it would only be on the national area.
But so my question is, the same story about Abraham Lincoln, that he asked his friend, if I'm holding my dog's tail off the leg, and he was like, my dog has an answer for the sword, but instead of that, what's called tail, it's still a tail on the leg. So I didn't really understand why why the focus is on attempting to redefine marriage from what is seen legally and historically, as opposed to creating the same rights in the civil and the civil, and why individual states, and that's in the federal system, can reach agreement with, this works for us, we want to recognize these kinds of relationships, including classic and we want to grant them, we want to grant them the benefits that really comes with marriage, and get around the whole problem. I don't understand why there's a need for this important and create a conflict when there's something that we want.
Would you agree that if in fact it was shown that the segregated system of drugs actually resulted in harm and assessment, that in fact we need to Europe?
Segregated system of what?
Well, segregated to the contract organization. In other words, you're saying civil unions, that seems fine, you go over the rest. If it turns out that you're right, you do not feel or there is no actual way to get all the rights, especially in this society that's happening. We do agree with an actual punishment by the denial of the word now. We do agree that
well, no, because I think that you set it up as a binary choice. Either you have it's a constitutional right, it's a fundamental right, and no state can create any impediment for exercising that right, or there's no remedy. And what I'm saying is that I don't understand why there is an alternative. I don't see it as a I don't understand why individuals, I mean, first of all, it wouldn't include the definition. And I don't understand why states can't come to their own resolution of the societal changes that we're just reality.
Yeah, and actually New Jersey, union. But what we found is that there was petitions, which I knew beforehand, because legally, there's, you know that in New Jersey, we don't have same-sex marriage. We do have same-sex divorce. That was the case that popped up in the because we had a couple that were married and had social stability. Well, you know, what the point was, they needed stability. They needed some clarity of what their rights were. Okay, because one sort of, you know, we're talking about civil marriage, one thing that they can talk about. One thing to ensure is the simple flow of rights from one to another. And if you're stuck being married to a person that you're trying to meet, it's not good. So this person, when family goes to Jersey, they're married, they need a divorce. They need that. You know, when we get to have it, we're married in Canada. Massachusetts doesn't matter where. And ultimately, of course, you have to define marriage. Number one, based on conformity. And we also raise the issue of you can't have a creation system that leaves your rights on the system. You can't have a system that where we find out whether there's hundreds of that's the right one being respected. But the human business does what it's the union. And my other question is, what is the response to my question? What is the response to the law? And so you have a right to know what's going to change, what's not going to change. Let's call you interracial rules. If there's nothing, no right to change. What's wrong with that? It's because it's wrong in the Constitution. We have wrong since the start. Because we recognize separate voting, but it's not equal. You know, it happened not only in U.S. versus Virginia. The idea of women in military. The idea that, you know, there is some problem is not allowing access to that which you deny access. You say you are not like everybody else. We're putting you to the side. We are quite literally segregating you from the right. And when I go back to, always come back to Justice Kennedy in 1928. And when he said, the government for the good or for ill would be potent and omnipresent teacher. The good for ill teaches society by instinct. And when our government is saying this group deserves less than you, they deserve to set aside to be different, then it is golden bigotry and it causes harm not only to the family but to the church.
Well, thank you very much to both of our participants. Thank you very much to everyone here who attended. The Federalist Society is currently seeking a board for next year, and we are having our elections next week on Wednesday at 6 p.m. Please notify me if you intend on running one of our numerous positions. We have sheets over there outlining some of the positions that are available. Also next week, the Federalist Society has two other events. First, we're co-sponsoring a debate with the SBA and with the American Constitution Society with Professor Gary Francione and Professor Dario Rindash from the University of California, Los Angeles on whether animals should be used for laboratory research. Then also on Thursday at lunchtime, we are bringing in Nick Nikas from the Bioethics Defense Fund, who is going to be giving an interesting presentation on human cloning and stem cell